also to defend the boundaries of constitutional roles and democratic responsibility. Let me be clear, this case is not about whether LGBTQA plus citizens deserve dignity. That is undisputed. This case is about whether who should make the law, the courts or the elected representatives of the people. Addressing the first issue, can Hindu Marriage Act and the Special Marriage Act be read to include same-sex couples? With respect, the answer is no. Both the Hindu Marriage Act from 1955 and the Special Marriage Act 1954 are clearly framed around heterosexual unions, man and woman, husband and wife, and mother and father. These are not accidental omissions. They are deliberate legislative choices. If the petitioners seek to rewrite these laws, they must go to Parliament, not to court. The judiciary can interpret laws, it cannot reconstruct the very foundation. Addressing the second issue, civil rights versus legislative process, the petitioner speaks of Articles 14, 15, and 21, and indeed those rights are universal. But universal rights do not automatically create new legal institutions. Marriage and adoption are not just personal choices, they are legal frameworks with complex implications, such as taxation, succession, custody, and adoption. To interpret same-sex couples in these frameworks, we need systematic reform, not selective interpretation. The court in Suresh Kumar Kaushal in 2013 rightly observed that changes to deep-rooted social structures must come from social consensus and legislative will, not judicial mandates. Addressing issue number 3, are customs and traditions exhaustive? Yes, your lordships, when it comes to religious rights and personal laws, our constitution protects pluralism, not forced uniformity. If the court redefines sacred customs without community dialogue, it may spark backlash and polarization, not progress. Let us not repeat the mistake of imposing reforms from above. Legal recognition must walk in step with public trust. Coming to issue number 4, can same-sex couples be married under religious rights? That is a question of faith, not force. Temples and priests have the right under Article 26 to manage their own religious affairs. Forcing them to perform same-sex marriages would violate their fundamental rights, just as denying their marriages may violate others. A constitutional balance must be struck, and that balance is best created by inclusive lawmaking, not judicial decree. Your lordships, rights and remedies must be carefully matched. No matter how emotionally compelling the plea, we must ask. If the answer is yes, we risk judicial overreach. If the answer is no, and respectfully it is, then it is the Parliament's job to study, debate, and legislate after hearing all voices, religious, cultural, and legal. Let us not undermine that process in haste. The respondent is not rejecting the community. It is respecting the Constitution and the separation of powers. We urge this Honourable Court to uphold the existing legal framework, recognize the need for legislative action, not judicial reinterpretation, and ensure that constitutional change happens in the right way, through democracy, not shortcuts.